My name is Laura Pfeiffer, and I'm here with my partner, Amy Dayhoff. I've been with the firm for 27 years. I co-chair our employment department, and I'll let Amy introduce herself briefly, and then we'll get to it.
Good afternoon, everybody. Again, apologies for the technical snafu we had on our end. Again, as Laura said, my name is Amy Dayhoff, and I practice in our business and employment litigation space. I also do employment counseling, and I have been with the firm not as long as Laura, but 20 years. So I've been doing this a long time, and thanks so much for joining us.
All right. So Amy and I are in an employment litigation subgroup here at the firm, and we talk from time to time about what types of things we think our clients might want to hear about, and what people have been working on. And Amy has had some interesting non-compete cases this year, so we thought that that might be a good thing to talk about. And then coincidentally, at the very same time, the FTC issued its notice of rulemaking with a sweeping ban on non-compete. So it was particularly timely to be able to speak to you guys today about that. And so we're going to address both topics, but we're going to start off with the FTC rule and what we can learn from that and what it even means or says and what employers could expect. So
yeah, and we're not going to bore you with a bunch of slides. We decided that we were going to do this as more of an interactive kind of question and answer chatting session. So kind of a podcast, but you get to see us is what we're going for. So
we're aspiring to be podcast people, but are not. So this is what you're going to get. All right. So as I'm sure most of you have read, the FTC, as of January 6th, had issued a proposed sweeping rule banning non-competes. So I think the first question is why the FTC? So why are they the agency that is issuing this, and how did this even come about?
Yeah, this is a great question. So
thank you
for a little bit of background here. So in July of 2021, President Biden in the White House issued an executive order. And to be quite honest, it was called Promoting Competition in the American Economy. And what they asked is they encouraged the FTC to, quote, consider exercising its statutory rulemaking authority, and this is the important part, quote, to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. And so they were really looking at asking the FTC to look at ways to promote or make sure that the companies weren't grossly abusing non-compete provisions.
So does the proposed rule do that? How closely does it track that initial directive and the order that was issued by Biden in July of 2021?
I would say it doesn't at all. I think that the FTC had good intentions when they issued the sweeping ban. And just to give you some specific statistics, 30 million people, so basically 1 in 5 workers, are subject to a non-compete right now. And so the FTC was looking at this proposed rule, and they're estimating that it would increase workers' earnings between $250 billion and $296 billion per year. And that's really focused on the low-level workers. But the problem is with this ban is that it's essentially an all-out ban on any type of non-compete. There is no carve out for any particular industries. There are no carve outs for certain levels of people.
So does it matter how much you make, or
it does not? It doesn't.
So the CEO of the organization is treated the same as somebody that doesn't have access to any confidential information.
Yeah, like the sandwich makers at Jimmy John's, which we all heard about those cases that happened about 5 years ago when they were having the sandwich makers or sandwich artists sign non-competes. So no, there is no differentiation between what level, what amount of money you make, what area you're in. So whether you're the janitor versus you're, the top scientist in the R&D department, there's no differentiation at all.
Right. So, I mean, we have always advised clients to, try to have non-compete signed with people who could actually hurt your business.
Right.
But here, this ban bans all non-competes, right? So it doesn't matter kind of what level you are. So does it cover more than employees?
It does. So there is not, it's not defined. So basically employees means independent contractors. It means employees, both people who make money and don't make money. So interns, if any there are interns listening, they're also subject to this. So it is grossly sweeping.
Okay, so are there any carve-outs?
Yes, there is one particular carve out, which is involves the sale of a business. As you all know, that's a really common practice when a company is selling. They usually have some kind of non-compete, non-solicits involved in those sales. For generally, it tends to be a period of 5 years, is what we see mostly in Minnesota.
Right, so much longer than an employment.
Absolutely,
That's closer to 1 year
or 18 months.
Yeah.
Exactly. And so that is a carve out, but only if you so you're still there's a 25% threshold on that, which, as you and I both know, will lead to absurd results.
Right. So, like, for example, if Amy and I and two partners of ours owned a business and we each had 25% interest, we could not have a non-compete when we sold our business because it has to be more than 25%, which, depending on the value of the business and what the buyer is trying to accomplish, has no proportionality there, right? So, or for example, if there was a huge business where the person had 24% of the business and sold, and they're benefiting greatly, say it's a very large sale, that person cannot have a non-compete at all either. So there's no proportionality. I think it's would create a lot of absurd results for our M&A partners, and also some, creative things that I think are not intended by what the FTC is trying to accomplish, where maybe somebody tries to put things in trust or kind of alters the percentages in a way just to try to accomplish the non-compete piece of it.
Right.
And so all of those things are really not what the initial directive, to the FTC was designed. But I think kind of illustrates how a lot of this proposed rule is really poorly worded and doesn't seem to really address what the initial directive was.
Agreed. And it will lead to creative lawyering with regard to, okay, so how can we get around this, right? And that's not what the FTC wanted, especially when we're talking about a sale of a business, right? Because like we said, these absurd results. So like you intimated.
When you buy a business, like you're not, you are part of what you're buying is some assurances that that person isn't going to turn around and start a competing business, right?
Absolutely.
So could really change the scope of negotiations and what people could accomplish. And all of that, I think, is very problematic to businesses, understandably. So tell me a little bit about, I understand this is retroactive. So what does that mean? And like, how are you supposed to accomplish that?
Yeah, so that's the other piece of this that's causing a lot of anxiety amongst, rightfully so, amongst a lot of our clients and just businesses in general. So let's say you had someone start right before this went into effect. There is a retroactive nature to this where you have to rescind those non-competes by the time within 60 days of when the rule becomes, if it does become, it will be litigated, but when it does become official. And so there's going to a certain type of notice that has to be provided, and it will be a rescission of all of those non-competes that were entered into, which also is completely absurd.
Yeah, so there's individualized communications. There's some language in the proposed rule. Again, we do think that there is very likely to be a lot of changes to this that, of course, we'll keep up to date on. But I do think one of the major grounds for challenge to this proposed rule is the fact that it is retroactive.
Absolutely.
Because that would also apply to the sale of the business.
It would.
Right? Like for people that had had a transaction expecting that there was a non-compete, so depending on, what the final wording of this is, you could have to rescind those non-competes as well.
Yeah, that's right. And anybody knows if you've entered into this large transaction with the sale of a business and you've got all of your non-competes and non-solicitation provisions buttoned up, and then to be told, by the FTC. Oh, sorry, you just bought all of this goodwill and bought all of this assurances by these non-competes, and oh, sorry, those aren't in effect anymore. You can imagine that's not going to go over very well. And so, speaking of litigation, there is, I know, a lot of questions out there about, is this really going to happen? I mean, is this really sweeping rule really going to take effect? And there's a lot of chatter out there. The first and foremost, I'm sure a lot of you have seen on the news and in various publications, but the U.S. Chamber of Commerce has come out and adamantly opposed to this. And so they have promised litigation as soon as it can be commenced. So we are anticipating a lot of litigation surrounding this. And in particular, the pressing issue right out of the gates is, does the FTC even have authority to do this? And was this what President Biden in the White House envisioned when he gave the in the executive order in July of 2021? And it's anybody's guess, but
well, and that would likely go all the way up to the Supreme Court.
Absolutely.
So,
And given
it's a constitutional issue.
Absolutely. But even besides that, there are going to be a lot of other, that's the first question that would have to be answered. And if that's answered in the affirmative, yes, they do have this rulemaking authority. That still doesn't mean that these won't continue to be challenged. One of the other issues is that the rule specifically says that it supersedes any state law. And so there are a lot of states that have been making some changes to their non-compete laws to kind of address some of the concerns that the White House had.
Right. Almost like that they've done so in a better way, right? A way that
100%.
was a little more tailored to the issue that was identified, where Colorado, for example, where you have to have a certain income threshold, or things
Absolutely.
that are noticeably absent from the rule here, right? Or California, that has had for a very long time, I believe it's back to the 1850s, they have banned non-competes. Even they have, the most strict state as it relates to non-competes allow for non-competes in connection with the sale of a business in a way that's not allowed by this FTC rule. So I think like some of the things that the states have been doing really is kind of what the FTC should have done, is to allow for something to be more tailored to the concerns of the low income, the wage earner, right? As opposed to such a sweeping ban as is on the books here. So
yeah, and that's I'm glad you brought that up, because we were talking about whether or not they even have the authority, and so that's the first question. But one of the things that I think is really important, is the specific issue is that the FTC, and because of all the statistics that they've given in support of this ban, is intent on combating primarily the use of non-competes with low-wage workers, right? And so, as Laura said, there are other ways to get around that. But the FTC's specific authority is to reduce unfair competition in the marketplace when it harms consumers. And so, arguably, they need to show that non-competes in general harm consumers, and that a ban also would harm consumers. And so, there's a lot of uncertainty out there because they're not, it's overly broad, and it's not tethered to actually what they're trying to accomplish. So that will be kind of the second layer of litigation, I think, that flows from, okay, do they have authority, yay or nay?
Sure.
If they do, okay, let's get to that next stage. So to be, I think we're all going to be watching this very closely.
Well, right. Yeah. I mean, I think there's a lot of additional things that will happen, and different ways that this could twist and turn. The FTC could adjust their rule to try to come up with something that maybe they should have come up with in the first place, that was more designed to address what the initial directive was by the order. So another thing I don't want to lose sight of is, does this ban only relate to non-compete covenants, or is it broader than that?
I'm glad you brought it up. So generally speaking, no, it doesn't. It's supposed to only be related to non-competes. However, given the broad nature of other types of provisions, confidentiality, non-disclosure agreements, non-poaching, all of those would be subject to this potentially. And so I think we've got to be really careful.
So though, right? Because there's a functionality test.
There is.
It's a de facto non-compete. So basically they were trying to say that if you are trying to backdoor a non-compete because your confidentiality
Calling it
provision
something
is
else.
like so broad that it
Yes.
effectively prevents you from working for a competitor, then that also would be banned as part of this proposed rule. But then like, what does that even mean?
Yeah, so this functionality test, it's to make that determination. So whether or not you're, because I think what they're concerned about and where we need to be careful is not using the phrase non-compete, right? And calling it something else, but in effect, that's what it's doing. It's banning worker mobility and their ability to go to other places. And so this functionality test hasn't been fleshed out really. I think that the best that we know is a perfect example. There is a non-disclosure provision prohibiting use or disclosure of confidential information. Is generally fine, but it's problematic if confidential information is defined too broadly. And there was just a recent case in the securities industry involving that specific thing, a non-disclosure clause that prohibited use or disclosure of any information concerning that specific industry. It was deemed by the court to be a de facto non-compete, and it precluded employment with a competitor because it precluded employment with a competitor. And the FTC cited to that particular case as an example of a non-disclosure provision that would be de facto a non-compete. And so we got to be really careful. I mean, as people are out there thinking, oh, well, can we just name them something else? And no. They're going to be looking at all of those provisions, even though this ban just says particularly it's related to non-competes. It's not.
Right. But I mean, that's also an area where employers are going to be really frustrated because,
Yes.
Like, what are you saying? We can't have confidentiality provisions? Like, that's insane. There's common law confidentiality obligations that employees have in some states. There's, I think 48 states has the Uniform Trade Secrets Act, including Minnesota. And so I think, the idea that you can't have a confidentiality provision or a non-solicitation provision is not a fair interpretation of this. But at the same time, I think it's frustrating and likely is going to lead to a lot of litigation about, well, what does that mean? And once the final wording of this, if anything does come to pass, which I think a lot of people think something will, hopefully it's much more narrowly tailored and more business friendly, that people revisit their confidentiality provisions to make sure that they couldn't unnecessarily be viewed as a de facto just because it needed to be a little bit more carefully worded, right? So I don't think anyone needs to engage in wholesale revisions to their confidentiality provisions today. I do think there are a lot of the same obligations that would exist for employees under existing law, and that's not intended to supersede, but more to follow on that. And another point where I feel like there is uncertainty for employers because it's very understandable. I'd say most of my clients have confidentiality provisions, and many do have non-solicits instead of non-competes as a way to maybe be more, allow for more recruiting to happen because you're not permitted, you're not preventing someone from earning a living later per se. You are just asking them to stay away from your employees and your customers. And so maybe a different way to attract talent, but still protect your business. And so I do think those things are still possible, but yet, this de facto concept is part of the rules. So we wanted to make sure people were aware of that. So
absolutely.
Okay. All right. So what should employers do now? Obviously, there's a lot TBD, as Amy said, here that we'll continue to follow. and report back to everybody, with additional updates and possibly a follow-up webinar if that seems to be helpful.
Absolutely.
But what are we recommending?
Yeah,
Like,
so
what should people do now?
Yeah, first and foremost, there is, just so you all know, there is a public comment period that is open right now. It's open, and it's open until March 20th. And what that means is you can either provide comments on directly on the website, or you can mail your comments. And so with regard to the website, the firm sent out, and hopefully you all are on the receiving end of those, an employment alert regarding this new sweeping ban by the FTC. And that can be found on Winthrop's website. The link, you can click right into it. That'll take you to the public comment, and that can be found on www.winthrop.com. If you want to provide some kind of written comment, I'll read off since we don't have slides, the address for you if you guys grab a pen and paper, but it should be addressed to the FTC, Office of the Secretary, 600 Pennsylvania Avenue Northwest, Suite CC-5610, and then in parens, you should put Annex C as in cat, Washington, D.C. 20580. That comment period is open until March 20th, 2023. And I want to caution you, Laura and I were discussing this previously or earlier today, caution you that this is public comment. And so be thoughtful about what you put, how you raise your concerns, and make sure not to disclose any kind of confidences with regard to your business or your industry. I don't know if there's anything else you wanted to add to that, Laura.
Yeah, I think it's just part of what could be persuasive there is how it would actually affect you and your business. And so in making that argument, we just want to make sure people aren't waiving anything or, sharing anything, or by not thinking that it would be, that it would somehow be confidential So just be thoughtful about doing that as you submit your comments.
I'm glad you brought that up, because I had some other statistics, and that it makes sense in the context of this, if we've got anybody here that's listening that's in the healthcare industry, for instance. I pulled some stats.
We do, actually.
Yeah.
I looked at the list.
Yeah. And so, for you guys, in terms of your public comment, what I saw in the research I did, for obviously in some industries, non-competes are more likely to be put in place. And one of those is studies have found as many as 45% of primary care physicians are subject to non-competes. And there's a reason. And I think that is an important for all of you guys out there in that industry to think about when you're doing your public comments. Another industry is, obviously, we all know, the tech industry. And studies show that 35 to 45% of tech workers are bound by non-competes. And there's a reason and a rationale. So all of you in the tech industry, think about that too. I mean, the stats bear this out, that you're in an industry that needs these protections.
Yeah, so the other recommendation we have for, what to do now is, since there is a lot to be determined still, is I know some of you on the call have a very good handle on exactly which of your workers and contractors have restrictive non-competes in their agreements. And so it's not going to take much for you to figure out what that is if you had to rescind those, if that ended up being kind of any final rule. Mm-hmm. But others I know, and we've had this come up when people have called us about litigation, is like, well, I think the person signed it. We can't really find it. I think it was, 10 years ago, but nobody knows where it is. Or we have I had one last week where it was, here's 2 pages of this, but not the signature page. And, so it would make sense both for this reason and otherwise to just do an inventory of, do you have people that have non-competes in their agreements? And then do you have full copies of those? And what do those restrictions say? And just to do I don't think you need to spend an inordinate amount of time, but, essentially an audit of what those look like. So it probably would be wise to do so for both reasons.
Agreed. Another thing that I think would be important to think about doing is in addition to doing the audit, which Laura suggested, and we're happy to give you advice on how to go about doing that in the most efficient manner, in addition to providing public comment to the FTC. But also, I think you should give some real thought to contacting your U.S. reps and senators. There is a growing movement amongst bipartisan support in the legislature for some type of restrictions on non-competes. Last year, for those of you that weren't following it closely, both the Republican senator from Indiana, Todd Young, as well as Democratic senator from Connecticut, Chris Murphy, introduced legislation to ban non-competes, and it garnered quite a bit of partisan support, nonpartisan support, bipartisan support, which we don't see a whole lot of these days. And so that's something to keep in mind. And I think that, as we're talking about what's going to happen this year,
right, just other things to follow. Right?
Absolutely.
Different ways this might come about in
that's right.
different format.
Absolutely. So keeping an eye on that. And also, just so you guys know as well, approximately 20 non-compete bills or previously pending in over 10 states. And that's including Connecticut, here in Minnesota, for those of you that didn't know that, West Virginia, Iowa, New York, Wyoming, and New Jersey, just to name a few. And so there's that. And then Laura mentioned it too, but there are states, regardless of what has happened, right, with FTC ban and what does happen, more and more states have enacted laws restricting or placing outright ban on non-competes. So North Dakota and Washington, D.C. have banned non-competes with really narrow exceptions. And then Colorado, Illinois, Maine, Maryland, New Hampshire, Oregon, Rhode Island, Virginia, and Washington prohibit non-competes with individuals making below a certain threshold. So there's a lot of activity in this space, and we're anticipating that will continue to ramp up in light of this FTC ban and what might happen with that. Now, the other thing to keep in mind is neither Laura nor I think that this FTC ban as written is what is going to actually become,
I think
quote,
we both
law.
think that would be very surprising. So if it was as written.
Absolutely. And so it is really important, again, to get your public comments out there, because whether there will be tweaks to it related to something with regard to the sale of business and the percentages, or certain types of industries, a certain level of executive, those are, I think, all on the table.
Right. Well, and it's just, there are meaningful ways that I know this will affect some of the people on this call and our clients. And so having people understand that, is important, and we would recommend, and we're happy to help as needed. So
absolutely.
All right. So as I said at the outset, when we first started talking about this potential webinar, it was because Amy had had a bunch of recent non-compete litigation where there was maybe some things to learn. I usually say that, in every piece of litigation, there is always something to learn, and that, businesses can appreciate both based on what the other side did and otherwise how you might want to change your practices moving forward, or things to keep in mind. So with that, I will toss it to Amy so she can tell us about, there's two in particular that we were going to share with you, and then some kind of takeaways from those. So tell us about the first one.
Yeah. So as Laura mentioned, last year, for whatever reason, was a very active year in my practice with non-competes, both, us both defending and litigating against. And there were a couple of them that stood out to me in particular, just because of the posture of those non-competes, the case, and what ultimately happened in them. Obviously, I'm not going to disclose any attorney-client privilege information. I'm not going to provide any names of individuals or companies involved. But the first situation involved a client of mine who was in need of an individual to work in a pretty specialized area in which they were beginning a new plant in a new location. And
so you were the new employer.
Yes. So we were new
considering hiring somebody that had an agreement.
That's right.
Okay.
And as part of that, the old co had a non-compete in place with this particular individual. That particular individual shared the non-compete with new co as required under his employment agreement. And we always advise that our clients ask if there is a non-compete
it's a
in
good
place.
practice to always ask that. I mean, you can't tortiously interfere with something that you don't know about, but you can end up in much further down the road with somebody than you want to be if you don't ask. And it's kind of reasonable to do that, right?
It is, and a lot of employment agreements that contain the non-compete or a separate standing,
kind of make you do it, right?
Exactly, it's one of the provisions in there, and so his had that, but we always ask, and so reviewing it. This non-compete in particular we weren't overly concerned with it. And the reason being is because of the language that was used in the non-compete. It didn't define, and this is the first takeaway, what the business was.
At all?
It just was a very, very broad, all encompassing certain kind of industry. Okay. And that was it. And so we also knew where this individual had worked previously and what his experience had been. And so we took his resume as a whole and realized, now wait a second, this is probably, this is, in my opinion, overly broad and isn't going to stand up in the court of law. And so
you were where again? What state?
We were in, so everything was happening in Wisconsin. Okay. And so we analyzed it and decided, you know what, no, it's overly broad because business was undefined and we're going to move forward. Lo and behold, this company then reached out with a cease and desist to both the employee and my client. And we responded and explained to them why we believe that the non-compete was unenforceable, because it was overly broad with regard to a non-defined term related to what business they were in particular. And so we decided to engage. And for those of you maybe have had some experience in this, there is this concept called a pre-suit mediation. And a lot of times it's a good idea because you can reach some kind of agreement outside of a court of law. It saves people a lot of money and everybody knows what the deal is, right?
The initial foray in non-compete litigation can be very expensive.
Very expensive because it usually involves a temporary restraining order, which is separate and apart from the complaint. There's a lot of briefing that goes into that. There's usually oral argument and there can be subsequent hearings that happen, which is exactly what happened in this case. And so we did not reach an agreement during the pre-suit mediation. We had provided an olive branch on how we thought we could assuage everyone's concerns. That didn't work. They sued in Wisconsin in state court and moved for a TRO. The TRO was granted only because the judge was on vacation. So we didn't actually even argue. So it was put into place. So that was problematic.
That's a windfall for them.
Yes, it was. Yes, it was. So then the next step in that was a preliminary injunction hearing. And for those of you who don't know what that is, it is essentially a mini court trial. I mean, it's abbreviated.
So what did the TRO mean? So he couldn't work?
He couldn't. So
what was he on, like a leave of absence?
He was. We put him on a paid leave of absence because he was a really important employee for us to have. And we felt very strongly about the unenforceability of this non-compete. And it was worth fighting about. He was an important employee and we knew that we had good arguments and felt really very solid legally on that perspective. So what do? We move forward and have this mini trial preliminary injunction hearing.
Okay, so what does that mean exactly?
So what that means,
how does that?
Yeah, so for those of you who haven't done that, you have all of your witnesses there. So employee was there, various people from my client were there, and various people from the other side were there. They also showed up with an expert.
Okay.
And you don't get any of this information ahead of time. So you don't know who's going to show up at the preliminary injunction hearing, who you're going to be.
Different than a trial where there's a witness list, right? So
absolutely.
you know what to expect. So
yeah, so that's why this gets expensive. when you're going down the TRO path, because if you get to this point in preliminary injunction, you have to be prepared kind of for this huge sphere of, okay, they could bring this person, they could bring this person, because they generally have provided some affidavits or sworn declarations of people that they've attached. So you're assuming maybe they'll bring them.
Right.
But in this case, they didn't bring all of
Okay.
those people, and they brought an expert that we had no idea about. So fast forward, we had this, they put on their case.
Okay.
We cross-examined all of their witnesses. And before
She was brilliant, of course. But,
yes,
you know,
it was,
but,
yes,
right.
of course. So at that point, they asked to take a break before we're getting ready to put on our case. And lo and behold, they come in and say, we'd like to settle this case. And so we go into a room, and what did we end up settling on? We settled on exactly the same terms that we had offered in the pre-suit mediation. And so, the moral of this story is I wish that the other side would have been more willing to come to the table on this, because we were willing to put some parameters in place to assuage concerns that they were worried about him providing some of their confidential business information. That's really what this came down to.
Were they worried mostly about him or other employees with the same agreement? Or, I mean, could you get a sense of that? Like, sometimes I feel like in these cases, it's little to do about the individual. It's all about either the competitor that they're mad about, or, or concerned, or they're worried about the next 5 people that have these, and, and what that's going to mean, and whether this employment or this new employer is going to continue to pick people off because they think they're an easy target.
That's right. And that's a really good question. In this case, it was twofold. It was him in particular, and the specific information that he possessed given the role that he had at the old co. But interestingly enough, and this is something to think about when you're deciding on going toe to toe with a potential competitor on non-competes, is they had reached out to one of our employees previously. And
see,
and but my client's non-compete was very different than the non-compete that we were looking at for their employee. A lot more defined, more narrowly construed with regard to the scope, the business, and all of that. And so they reached out to a high-level employee. We reached out and said, no, this is what the non-compete says. And it came out through the course of this in the pre-suit mediation, actually, that they were still peeved about that. And so I do think that, in addition to really thinking about, obviously, looking at the scope of how business is defined, because it's really important that you don't have an overarching, anybody who's in the automotive industry, or you name it, whatever, healthcare industry, tech industry, it needs to be specific to that subsection of that industry that you're in. Because otherwise you run the chance of it being completely thrown out, or blue pencil, depending on what state you're on, which state you're in, which means
the judge edits it.
Absolutely, which you really don't want anybody editing your non-compete.
Yeah, I mean, it's better to have you do it yourself on the front end in a way that, would matter to you, instead of, having a judge do it. Because I often say that, like, when people ask me about non-competes, is that I have had ones that I've won that I probably shouldn't have won.
Yes.
And I have had ones that I've lost that I've been stunned.
Yes.
And I think some of it really depends on the individual judge and their attitude towards non-competes.
Yes. And the state you're in, too.
The state, and obviously the state law differs.
Yes.
I also think the facts matter. Like, if you can tell a story, like, I don't know why your guy left, but if it's like, this person is not getting paid enough and they tried to work it out there and they need to advance their career, support their family.
And he didn't get a promotion, and that's what happened.
Right.
Yes,
so good reasons to go,
That's right.
as opposed to that somebody is trying to poach them to steal everything. And, like, so I think if you have a good narrative in that,
Agreed.
and the employee hasn't done anything foolish, like taken stuff or, I had one employee that was a departing employee that I was representing, and he had a very bad habit of using jump drives. And so, but it was just like, that was his way of like having information, and so it was all very legitimate, but it looked really bad on his computer because when he left, they got real mad and examined all of that. And I was, when I talked to him later, I was like, you're not allowed to use jump drives anymore.
Right.
Like ever, because it was such a bad, I got it thrown in my face so much by opposing counsel.
Yeah,
so
exactly. Yeah. So I think that, right. You do need a good narrative, but to get back to the 2 points.
It helps. I mean, you can't choose the narrative,
That's
but
right.
It really, if you're in front of any of it,
right.
To counsel about, how the departure is happening or what's the communication back or, being forthright, I think is generally the best approach.
It is. And just really keep in mind, besides the, looking at how you've got your business in particular and industry tailored, is thinking about how you pursue others with the non-competes, because that is exactly, it became kind of a tit for tat. Actually, it wasn't necessarily, it was about him, but there was this really strong undercurrent of, well, wait a second. And the interesting thing about that is the non-competes were entirely different, but in their mind, they wouldn't differentiate, and they were just mad. And it wasn't necessarily, it was this company's C-suite that was mad about it. And so they were willing to fight about it. And it cost my client a lot of money, and it cost them a lot of money too, though. And at the end, we got to the same resolution we would have had tens of thousands of dollars sooner. So,
right. Well, and then, isn't it fair to say that because it's so expensive, a lot of people give up once the TRO is granted, right?
That's right.
Here, I think there wasn't, sometimes you view it as meaningful as to what the judge says with that TRO, as to whether it kind of is reading the tea leaves as to whether you're going to win or lose, like moving on, even though the standard, it's not like were you harmed at all. It's whether there's a likelihood of success on the merits,
That's right.
And there is no way to address this by money damages. An injunction is needed to preserve the status quo. So, the standard is very specific, but at the same time, you kind of view that as meaningful as to like, should I continue to spend money on this person, right? Because even though Amy's client was interested in this person, they didn't know. Right? Like it's like you're spending a lot of money on somebody that's kind of an unknown quantity.
That's right.
And that's hard to stomach sometimes.
And in this particular situation too, I'm glad you brought that up. A lot of times you can read between the lines in the judge's order related to a TRO if one is granted, but both for and against you. And in this case, it was against us, but because it was literally, he was going on vacation and it was getting it off his desk, there was no reading the tea leaves. It basically was like granted. And there was nothing else. And so we figured out after the fact by calling around and trying to figure out, wait a second.
What happened?
We had a hearing scheduled on this and we haven't even been heard on it, and he granted it. Right. And so
it was the vacation preserving of the status quo.
It was. So unfortunately, we didn't have a read going into this preliminary injunction hearing and what was going to happen. So, all of that is good food for thought. You really need to think about, whether you're pursuing somebody for a violation of a non-compete, and how far you're willing to go, and whether it makes sense to try to sit down early on and come to some kind of agreement. And we see that a lot. Speaking about back to the FTC sweeping proposal, non-competes serve a great purpose, and I'm not telling you guys in the audience anything that you don't already know, but there are ways to actually allow worker mobility, right? And even to go potentially to a competitor, that you work out agreements with the other side, and everybody saves a lot of money and headache. And that was just, they weren't willing to get there until either making us spend a lot of money. I'm not exactly sure.
Destroyed all their witnesses.
Exactly. That's exactly what happened. Yes. So
then they came to their senses.
Exactly. Thankfully.
All right, so lessons learned from that one. Obviously, the business not being defined
Yes.
allowed for you to really make some traction there, right?
It really
were
did.
there other things that the other side did that were a mistake, or
Yeah.
things to kind of
Yeah.
takeaways on that one, and then we'll talk about your other one.
Yeah. The first shot across the bow letter that we received from it wasn't even in-house counsel. It was someone in the business. They didn't provide any. So the letter was all of 2 paragraphs. And when I say 2 paragraphs, the paragraphs were maybe 1 or 2 sentences each.
Okay.
And it literally said, almost to a T, we feel like, and let me back up. This is important to note too. There was a dialogue going back and forth between our client and NewCo or Oldco about what his job description was, what he was going to be doing. I mean, there was a lot of that back and forth.
Before the lawyers.
Yes. And I highly encourage that you do that, because more often than not, you're going to get to some kind of an agreement. Even if counsel gets involved, you're not going to get to where we did. And again, this goes back to, I really think it was driven by the tit for tat piece of that. But the letter was basically non-committal. It didn't say it didn't lay out what the non-compete provision was that he was allegedly violating by coming to work for us, what the position that he was coming to work for us, how that violated it. There was nothing in it. It just said, we think that it violates the confidentiality provision contained in his agreement. So that didn't get us anywhere, right? So the response back was, well, here's what it says, and here's why it doesn't. Then counsel got involved, and unfortunately at that point things went off the rails. But so I think it's really important. So takeaways, it's got to be defined. Making sure that you tell the employee, if their agreement says that they need to notify their old employer about a new job, they need to do that. And then that opens up the ability to have a conversation pre-litigation. Number one, they're not violating their agreement. And number two, you can avoid a lot of this. Unfortunately, in this situation,
even if the agreement doesn't say that, I usually say that you should tell the person where you're going. And when clients kind of push back on that, I'll say, how soon are they going to find out otherwise? Right. And most of the time, if it's like through LinkedIn or somebody knows somebody, or the industry is real small or whatever, well, then if you say, I prefer not to say, and then they find out, oh, it's there. It looks like there's something going on that's shady, because otherwise, why wouldn't you just say, right? And so I feel like it just takes the wind out of those sails. And occasionally there's somebody that won't figure it out, and maybe that's a good idea. But overall, I think the departing employees should be honest about where they're going.
I agree, 100%. So that's another takeaway for sure. So, Yep.
All right. So tell us, what was the second one?
Really quickly, because I know we want to get to takeaways. This involved my client's non-compete. We had a very senior person in research and development department that had not been honest with us about his intentions. He had claimed.
You're Oldco here.
Yes, we're Oldco, so we're switching.
Yeah.
Exactly, it's our non-compete that we're defending against, and are defending. And so he had told us he was having some health issues, and that's why he was leaving. And then
so he was not forthright.
He was not forthright.
Again, looked shady. So
exactly. Then we find out he went to what we believed was a competitor based upon, again, the definition of the business and the industry. We immediately filed a lawsuit and obtained a TRO because this was a really important. He was developing all of our product, so he knew everything.
Okay. So was the type of things that non-competes are supposed to protect, right?
Absolutely. Absolutely.
Not overreaching,
not at all.
Sort of caught in the fray of too broad of a non-compete.
Exactly.
Okay.
And so we felt comfortable moving forward on that. We sued, brought a TRO, and before the hearing, we were immediately contacted by counsel for NewCo, as well as he had separate counsel for the employee, and they immediately wanted to reach some kind of settlement. They did not push back a lot. They did a little on the non-compete, which you need to do. But we were able to come to an agreement that, as I said earlier, assuages everybody's concerns,
So
right?
he could stay,
He could stay.
but,
But there were lots of parameters
Okay.
about
all right,
he couldn't put on social media, LinkedIn, that he was working for this company. He had to be in a separate company or part of the company, segment of the company for the length of his non-compete.
okay.
And so we
That
worked
was non-competitive.
exactly
Okay.
non-competitive. And so, what I want to stress to you guys out there is I know it's traumatic when you have a really important individual leave, but all is not lost. And there are ways short of litigation to reach resolutions that are going to, everybody's going to be happy, right? A compromise. And so that's my main takeaway from that one is that he was a really
Creative.
yes,
right?
exactly. Think outside of the box because there was a statement that would have to be provided by the new that they had checked his emails and things like that, and that nothing was happening that had to go to the CEO of our company.
Okay.
So it's things that you're never going to get in a court of law that I think is a huge takeaway on these non-compete pieces of litigation.
Right. So maybe, because sometimes I think people think, well, if it's at company X, then absolutely not, because we won't believe
Absolutely.
that they're not doing these things or,
Mhm.
that, yeah, sure, they're going to farm them off to the side, but like, I don't believe that. Right. But, people are, you are supposed to earn a living, right? Companies like
That's right.
the judges view non-competes with somewhat disfavor.
They
They
do.
want them to be narrowly tailored and designed to protect your interest. And so if there is an ability for somebody to be in a different department or, and especially if you have some teeth to it, right?
Yes.
And I assume like if they left, the non-compete was still enforced, right?
Absolutely.
Right? So it's
Absolutely.
not like they could get their whole non-compete voided and then quit that place and go somewhere else,
That's
right? So
right.
I think like if you are creative and
Mhm.
thoughtful about a solution, you may be able to get the certainty you need, but avoid, the litigation.
The litigation and the
Makes sense.
uncertainty of litigation,
Right,
not only
right.
the expense, but I mean, as Laura said,
You're controlling your
yes,
destiny on
you are.
what that looks like.
That's right.
So, and like Amy said, like you can't necessarily get some of those assurances from an order, right? Because they're far more detailed and than would be the norm with that. So,
That's right. Absolutely.
Gotcha. Okay, so. All right, so we're getting
Yeah,
close to the end of our time here. So what other things, just as it relates to general non-compete stuff, we're real close to the end of their time. So we have some questions. So we'll take a look at those later and try to get back to people. But I don't think we're going to have time to go through them in
Sorry,
the last 3
but
minutes.
we
here,
will
which-
reach out to you.
Yeah,
So,
we
yes.
just found out about those just a second ago.
Yeah, so I think some of the things that the takeaways for you guys, obviously it's an evolving landscape with regard to non-competes, both, obviously with the FTC and what's going on, but also state by state. And so we need to be, you got to be strategic and targeted use of non-competes. I think that as a company, you need to, Laura had talked about kind of this audit process for your non-competes and just going back and seeing who has them, are they all signed, that kind of good housekeeping. But also, why do we have these? Right? Do we need these going forward? What is
Are
the
they doing
rationale?
what we're
Yeah.
wanting them to do, or
Right.
are we just doing this because they've been in place for a while?
Yeah, and you're on
and-
autopilot, right?
Right. Or
Right.
should there be some adjustments to them? Or, one thing we've been talking to a lot of people now about, not just with respect to non-competes, but generally, is with post-COVID remote work arrangements, are people in different states now in a way that you need to think about, right? So like if there was somebody that used to work here and had a non-compete, and then now they are working permanently, they live in California,
Mhm.
right? So that needs to get revisited because California bans non-competes for people that live within their state, right? So there's some things to think about and be thoughtful about as it relates to some of the developments with non-compete state by state, and that remote work. It also relates to leave of absence things and,
Yes.
other things that you maybe need to be compliant with for people in different states, but it also relates to non-competes as well.
Yeah, and I think finally, I think the most important thing for me is just making sure that they're narrowly tailored. And I know it sounds like we're beating a dead horse here, but I can't. I mean, I've been practicing in this space a long time, and that's really where we see the action. If it's not, and when it's like with regard to what are you keeping them from competing, right? Is it in a certain industry? Is it a certain product line? Is it a certain customer? Right, all of those things. I think that depends on the company that you're running or involved in, and you just one size doesn't fit all, and so I think you need to be real thoughtful about those and whether or not yours are narrowly tailored to try to be as enforceable as possible. Should that ever come to pass?
Yeah, I think a rule of thumb with that too is that, like, if you have an overbroad non-compete and it restricts a lot of people from working in a lot of places, the reality is, like, who would you spend the money on to sue? If they went there, like both what they know, what it's protecting against, and what it's preventing them from doing, right? Because if it's like all sorts of other things, which the reality is, like, you probably wouldn't go after that person if they did that. But that's what the non-compete says, and the plain language of it, it's probably worth revisiting to see if some of that should get tightened up.
The last and one more thing, because I know we're running out of time here. In closing, too, I would say that when you have a broad non-competes and you've got a lot of people that have signed them, you want to be really careful about that, because if you have someone that leaves, right, and you're like, oh, they're not that important, but they have this non-compete, we don't want to spend the money on them. Well, you need to think long and hard about that, because if that person goes and then talks to his friend that also is still employed by your company, and they say, oh, I left and they didn't do anything about it, you can get yourself into a world of harm. And so I can't tell you how often we have that conversation with the client, like, okay, we should enforce this, because if we're not going to actually actively go out and enforce our non-competes, why do we have them?
Right. Well, because it's been waived, right? And
Yeah.
so, and then it's also that if you allowed that person to do that, well, then it's obviously not needed to protect your business because you did that.
Right.
Now, with Amy's examples, they did go after so if it's like, well, wait a minute, you allowed, like in your second example, you allowed that person to go there. It's like, well, no, there was a negotiated resolution there where it wasn't that you just like let it happen and pretended like you didn't know, right?
Right.
So
right.
All right. Well, I think we're at the end of our time. So we really appreciate everybody joining us. We hope you found it to be valuable. We're sorry we didn't get these questions until 2 seconds ago, but we'll take a look at them and see if there's some follow-up that we can provide to everyone. So, but otherwise, everyone have a great afternoon, and thank you for joining.
Yeah, thank you. Bye-bye.